Well, my dear students, I welcome you once again after this short break. So, now we are going to talk about the content from section 3 of chapter 2. Okay, so from this chapter 2, section 3, we will be covering only two topics. First one is doctrine of precedent. This topic is so important, not only because I'm going to introduce few very difficult legal terms, but also the common law legal system that we follow in Australia. It's based on this doctrine of precedent. During last week's lecture, even in the first half of my lecture, I have mentioned precedent quite a few times, but now let's go through it. So, the doctrine of precedent specifies that a court should apply the rulings of previous cases in situations where the facts are similar. More specifically, a court is bound to do so if the previous case was tried in a higher court. We just have talked about the hierarchy of the courts, right? So to understand doctrine of precedent, you must have an idea about the hierarchy of the court. The doctrine of precedent will be applicable not only in a situation where there is a higher court, but in the same jurisdiction. How many jurisdictions we have in Australia? 8 jurisdictions, 6 states, 2 territories. So when I am talking about higher courts in the same jurisdiction, I am referring to one of those jurisdictions. Say in WA, we have at state level, we have the courts, Supreme Courts, District Courts and Magistrate Courts. That's the hierarchy. In New South Wales, we have Supreme Court, they have their county courts and local courts. That's their hierarchy, right? So 2 separate jurisdictions. So because of this doctrine of precedent, judges' decisions become binding on the future judges in the same jurisdiction. And that's how judge-made law or case law has been developed in England. When we say common law was established or developed in England, that's how it was developed, based on this doctrine of precedent. This doctrine of precedent has its advantages. That's why in England it was developed. In all the colonies all over the world, former British colonies, they followed this doctrine of precedent in their court systems. First advantage is this doctrine ensures consistency. So if there is a similar case, if the case was heard in 2000, even a similar case in 2020, 2024, the parties can expect similar judgment because of this doctrine of precedent. So judges will follow their previous ruling, previous judgment, and that ensures consistency, that ensures predictability. The lawyers can, give somewhat assurance to the client. Look, this is your case. A similar type of case happened, 3 years ago, and this is the outcome or judgment given by the judge. So there is some kind of certainty, a predictability whether they will pursue this case or not. The next advantage is flexibility. What does that mean? Judges in the higher courts are able to develop and update the law to take account the social changes that are happening so rapidly. Their decisions may influence the parliament members to introduce and enact new legislation, because enacting new legislation, that may take longer time, that it requires a social movement. We need to send our representatives, we need to wait for next election, and then in the parliament they will come up with a piece of legislation, right? So there are few advantages of judges making the ruling, judge-made law, those type of things. The law doctrine can also help in ensuring justice. That means someone got one type of verdict, we can expect even in future other people will get similar type of a verdict. So it ensures coherency, justice, promote consistency, all those things. But at the same time, this doctrine has its loopholes as well. For example, it's very rigid. Right. So in this same situation, this was the verdict, and we expect that the similar type of verdict will be given. There is no scope of playing around. If there is a precedent, say Supreme Court of Western Australia has created a precedent, a lower court cannot defy that precedent, cannot come up with something new, a new verdict or new judgment. No, they can't do that. So in that sense, this doctrine is very rigid. Some people say, it's outdated, because in Australia, sometimes we are following precedents which were established in, a case that was heard in 1920, for example. Right? Society has evolved, but because we are following doctrine of precedent, why we're following these age-old cases. If there is any mistake made and a precedent is based on a mistake, then it is really problematic. A magistrate court or lower court cannot correct that. The matter has to be taken up to the higher level, and if a court of record creates a new precedent, only then it becomes corrected and it becomes a new doctrine of a new precedent, right? So it has its loopholes as well. So here I am sharing both advantages of this doctrine, disadvantages of this doctrine as well. But at the end of the day, we need to know that in Australia, the court system is based on this doctrine of precedent, and it is functioning properly. The countries which follow common law legal system, they all follow doctrine of precedence. They follow case laws as their sources of law. But in some European countries where they follow civil law legal system, they do not follow precedent. They do not follow case laws. They follow codified laws. Right? So that's how these major two different legal systems we had. We talked about them last week. Now what I'm going to do, I'm going to introduce 4 principles related to this doctrine of precedent, and they are really important in your exam. If you can expect a question as a short answer type question, you may expect questions from this topic. This is so important. So these are 4 Latin terms. We'll go through each of those Latin terms. It may sound very weird, it may sound very complex, but as I promised, I will try to simplify those concepts. I have few videos to share with you, short videos to share with you, what I will do, I will talk about the first 2 principles and then the third and fourth one together. That's how it makes more sense. The first principle is stare decisis. This is a Latin term. Stare means stand by. Decisis means stand by the decision. Decisis is the decision. So stand by the decision. I'm just introducing the 4 principles first, then I will go through in detail. Next one is res judicata. The Latin term res means thing, and judicata means judicated, judged, the thing which has already been judged, adjudicated. That is res judicata. Ratio means a rational or reasoning. Decidendi is the decision. So what is the rational justification of the decision? That is known as ratio decidendi. Obiter dictum is means by the by. Sometimes the judge in their judgment mentions few things by the by. Just by saying. So let's go through one by one. Stare decisis. This is the policy of courts to abide by the principles established by decisions in earlier cases. In Australia, as we follow a common law legal system, under stare decisis, once a court has answered a question, the same question in other cases must give the same response, and that response must be given by the same court or the lower courts in the same court's hierarchy. So if there is a question that has been answered by the Supreme Court of WA in the similar cases, similar situation, whether it's district court or magistrate court, they will give similar answer. That's what we call stare decisis. Now I will share a video with you, and the video is based on the US system, but they kind of follow similar stare decisis concepts. So even if the video talks about US, don't worry. Here we go.
Stare decisis is a Latin term. It means to stand by things decided. Stare decisis is a doctrine used in all court cases and with all legal issues. A doctrine is simply a principle or an instruction, but it's not necessarily a rule that cannot ever be broken. The doctrine of stare decisis means that courts look to past, similar issues to guide their decisions. The past decisions are known as precedent. Precedent is a legal principle or rule that is created by a court decision. This decision becomes an example or authority for judges deciding similar issues later. Stare decisis is the doctrine that obligates courts to look to precedent when making their decisions. These 2 principles allow American law to build case by case and make our legal system a common law system. For example, let's say that Blue borrows Red's lawnmower while Red is away on vacation. Blue doesn't ask Red for permission. Blue accidentally breaks Red's lawnmower, but he doesn't tell Red. he simply places the lawnmower back in Red's garage. When Red returns home and discovers the broken lawnmower, he demands that Blue buy him a new one. The two end up in court, and the court decides that Blue does owe Red the money it requires for Red to fix his lawnmower. However, Blue does not have to buy Red a new lawnmower. This decision becomes precedent. From now on, lower courts in the same jurisdiction are expected to follow this new rule. When a borrower breaks a borrowee's item and was using the borrowee's item without permission in the first place, the borrower must pay to have the item fixed. Lower courts will follow this new precedent because the doctrine of stare decisis tells them they should. So, stare decisis is essentially the rule of precedent. Courts cite precedent when a court has already considered a particular legal issue and the court has already issued a ruling. For example, now let's say Green borrows Yellow's car. Yellow left the car at Green's house the night before and left the keys in it. He told Green he could move it if he needed to, but he did not give Green any permission to drive the car anywhere. Green gets up to go to work and finds that his own car will not start. Because he's already late, he borrows Yellow's car. Then, on his way to work, Green accidentally runs over a curb and damages Yellow's car. When Yellow sues Green for the amount of his insurance deductible, the court will cite to the case of Red versus Blue. Under the doctrine of stare decisis, courts are expected to follow their own previous rulings and also the rulings from higher courts within the same court system.
Okay, so let's stop here. The rest of the video we can explain. So stare decisis, you see that once there was a ruling, then on the same subject matter, whatever cases in future the same court or in the same hierarchy the other courts will hear, they will follow the same verdict, right? So that is stare decisis, and which are the courts can create the precedent? They are known as the Court of Record. So the High Court of Australia can create a stare decisis. The full court of Federal Court, then the appellate division of the Supreme Courts at the state level, Supreme Courts, they are known as the courts of record. Now, when we are talking about stare decisis, we need to keep in mind it's happening in the same hierarchy. That means if there is a stare decisis in WA, the courts in WA, they are bound by that. It is not binding on any court in another jurisdiction, in New South Wales, for example. The next one is known as res judicata. Res judicata means things already been decided, and if the court has already heard something, we cannot bring that case again and again. So let's watch another video on res judicata.
Professional emails is hard, and I don't even know what I was doing before Grammarly. While scrolling, I see that Grammarly added a new AI feature where you can set goals of how you...
In this video, we will discuss
Okay, res judicata in the US system, they call it as claim preclusion. So don't, they are the same thing. So the content-wise, they are the same.
claim preclusion. As a practical matter, claim preclusion prevents parties from suing each other over and over again after a case ends. In other words, when a civil litigation is over, it's over. For example, let's say we have Patty, who's happily driving her car. David comes by on his truck. Unfortunately, he's distracted talking on his phone, and David crashes into Patty's car. So Patty sues David for negligence, and we'll say she's claiming at least $500,000 in damages. The jury agrees that David was negligent, but only awards Patty $100,000. Patty's upset. She wanted a larger damages award. Then Patty gets an idea. Why don't I sue David again? She could sue David in a different court, with a different judge, a different jury. And come to think of it, America's a big country. Why not sue David in a different state for the remaining $400,000? And remember, in the first case, Patty only sued David for negligence. In a second case, why not allege that David intentionally hit her with his truck? The doctrine of claim preclusion tells us that Patty probably can't sue David again. Claim preclusion generally prohibits the same parties from suing each other again based on the same underlying incident. In our example, we have the same plaintiff trying to sue the same defendant again. And the second lawsuit is based on the same underlying event, the accident between Patty and David. Because a jury reached its verdict in the first case, Patty probably can't sue David again based on that car accident. Claim preclusion tells us that this case is over and it's time to say goodbye to the litigation.
Now, we need to keep in mind when we're talking about res judicata or claim preclusion, the case has been heard finally. That means if someone is dissatisfied, they have exhausted their appeal opportunity as well. Finally, the case has been heard and the final verdict is there. Only then if someone wants to bring the case again and again, it's just wastage of the time and resources of our court system. That's why this doctrine of precedent we follow as res judicata. The other thing I want to clarify that res judicata and the stare decisis, they are two different principles, right? In stare decisis, what happened? You see, the original case was between red versus blue, right? And that precedent is now being followed in another case where the case is between green versus yellow, two different parties. Right? That's where the stare decisis applies. But for res judicata, it's the same party, right? The same parties are trying to bring the case again and again where the original verdict, the final verdict being given by the court. Does it make sense? Do we all follow how they are different from each other? Any question? The other two principles, let's go through quickly. I'm mindful about the time. Ratio decidendi and obiter dictum. They are really easy to understand. Ratio means whenever the judge comes up with a decision or gives the verdict, the judgment usually, the judgments are usually very long, 80 pages, 100 pages even. So in that judgment, the judge actually mentions the rationale why the judge gave this verdict. That rationale actually creates the precedent. I want to share an example with you guys. If you have your text with you, I will request you to go to page 72 of your text. And there you will find this case law, Hurley Byrne and Company Limited versus Heller and Partner. This case law we will cover next week. I'm not going in detailed discussion of this case law, but I wanted to show you something. If you go to page 72 and the decision of that case law has been mentioned in at page 73, you will see the fact, the decision. There you will find, the ratio decidendi. Why this decision was made, that is mentioned in that example. So a ratio decidendi is the rationale or judgment of a case based on which the judge gave the verdict. Whereas obiter dictum is when the judge is writing the judgment or giving the verdict, by the by they can mention many things. That's not part of the original rationale of this judgment. It may have no relevance of the judgment that the judge has given. They are known as obiter dictum. Again, I want to give the same case law as an example. So this time I will request you guys to go to page 360. And there you will find the same case law, but in detail it has mentioned that the decision, this is the decision. The obiter dictum, it says, again, I'm not going in detail of the facts of the case. By the court mentioned, if the liability arose because of pure economic loss, maybe then the judge could find a negligent misstatement in this situation. So in that case, or in the original judgment, the judge didn't find that. But by the judge mentioned about this pure economic loss. And you know what? After this judgment, maybe after a few years, there were few pure economic loss cases were filed where this, obiter dicta was referred, this case law was referred. So by the judges sometimes can refer something which is known as obiter dictum. But the difference between obiter dictum and ratio decidendi is, ratio decidendi creates binding precedent, whereas obiter dictum cannot create binding precedent. So what is that? we talked about 4 principles of precedent. We can classify the precedents into 2 categories. One is binding and the other one is persuasive. So if there is a judgment that is binding, say Supreme Court of Western Australia, they gave a verdict. That precedent is binding all the inferior courts in Western Australia, the district court, the magistrate court, they are bound to follow it. But the Supreme Court in New South Wales, they are not bound to follow it, right? So those judgments in other jurisdictions will be known as a persuasive precedent. It's not binding, but they can take inspiration. If there is a binding precedent, a judge cannot follow a persuasive precedent. For example, in WA Supreme Court, a judge is facing with a case for the first time, say it's cybersecurity, say it's AI or whatever. It's so new, there is no precedent, binding precedent in Western Australia. How to give a verdict? The judge may take an inspiration from an international case. Or maybe in New South Wales, another judge gave a similar type of a verdict in a similar type of situation. That is not binding on the Supreme Court judge in WA, but they can take the inspiration, and that's how persuasive precedent works. I'm so sorry I'm not taking any question, but if we have time, we will do that. Statute law, I think last week we have talked about, historically, how it works as a source of law, and in our lecture, we will have only one lecture during week 10, I guess, where we will be talking about the statute legislation. But today I wanted to share with you how statute law is enacted. So one last video, and with that we will conclude our lecture.
One of the most important roles of the Parliament is to make laws. Laws that affect every one of us in many situations each day. But how many of us know how law is made? Parliament of Victoria explains how Parliament makes laws. It all starts with an idea. The idea can come from members of Parliament, political parties, ministerial advisors, public service, interest groups, media, and members of the public. The government chooses an idea it wants to make into a new law and puts it into a bill for the Parliament to consider. And a bill that is passed by the Parliament becomes a law. Both houses of Parliament need to approve a bill for it to become a law, the Legislative Assembly and the Legislative Council. Most bills start in the Legislative Assembly, with a member, usually a minister, introducing a bill. Members then vote whether to consider the bill. This is called the first reading. Next, usually after a few days, the minister explains the bill. This is called the second reading speech. The bill is now public, so everyone can read it. After the second reading speech, members have usually 2 weeks to study the bill and consult the community. Then members debate and vote to pass the second reading. Members may then enter the consideration in detail stage, where they debate and vote on each clause and any amendments. Now the bill is ready for the final stage in the first house, the third reading. This is a last check to make sure members still approve the bill. When the bill passes the third reading vote, it is sent to the second house and goes through the same stages as in the first house. Most bills start in the Assembly, but sometimes a bill might start in the Council and go the other way around. It doesn't matter where the bill starts. When it passes all 3 readings in the second house, it has successfully passed both houses of Parliament. So, is it a law yet? Almost. It just needs another very important thing. It needs the Governor to give it royal assent. The bill is now a law and called an Act of Parliament, but the law might not apply yet. Sometimes the government needs time to get ready for the new law. For example, to inform the public. The law may include a start date, or it can be announced later. So, how does Parliament make laws?
Okay, any question? Anyone? If not, thank you.